gotta stay out of my head. Stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do the make it for time that I've lost. Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I fail and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, James Frederick Williams, 42, U.S.C, 1983, Federal Lawsuit, Part 3. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so as you all know, this is part 3. So for all you guys who haven't watched part 1 and part 2, simply pause the video now and click on the links in the description box, okay? Which leads to video 1 and 2. Alright? So, for those who did watch part 1 and part 2, let's go over a quick recap of what has taken place so far. We know that Part 1 was dealing with James Frederick Williams' original complaint that was given to him from the fraud of law to file in the federal court. Okay? Part 2 was the defendants, Maximus and Stacey Elrod's motion to dismiss the original complaint. Okay? Part 3, which is this video, will be dealing with the rebuttal sent to James Frederick Williams from Virus, the fraud of law, to rebut the motion to dismiss that was filed by Maximus and Stacey Elrod, okay? So now, let's pick this up at the top. It states, in the United States District Court, Eastern District of Tennessee at Chattanooga, right? We all know the same parties that are involved. We have the plaintiff and we have the defendants. They are the exact same from before. Okay, so let's continue on. It states, notice of response to Maximus Inc. and Tracy Elrod motion to dismiss. It should be Stacey Elrod, not Tracy Elrod, but let's continue. It states, comes now. James Frederick of the family Williams, the party aggrieved with a reply to the defendant's hodgepodge, frivolous motion to dismiss by factual law titles. I never read a document or legal document that uses the terms hodgepodge. That's a little bit of a stretch or reach for him to use those terms, but let's continue. It states, and in support thereof, the court should deny the motion to dismiss for following. It should be for the following or for the following. Let's continue. 1. Subject matter jurisdiction is proper. Subject matter jurisdiction is proper in accordance with 45 CFR subsection 303.107, requirements for cooperative arrangements. The state must ensure that all cooperative arrangements be specified standards of performance which meets. Alright guys, we're going to page 2. Let's continue on. Federal requirements. C. Specify that the parties will comply with Title 4D of the Act, implementing federal regulations and any other applicable federal regulations and requirements, not the state. Wherefore, Section 460 of the Social Security Act provides that the district courts of the United States shall have jurisdiction, without regard to any amount in controversy, to hear and determine any civil action certified. A civil action under Section 460 may be brought in any judicial district in which the claim arose, the plaintiff resides, or the defendant resides. 2. Diversity jurisdiction is proper. Maximus operates in this state under contractual obligations to the 42 U.S.C. 654.3 single and separate 4D program, which performs under 31 U.S.C. subsection 6305 contractual obligations to the public law 93-647 separate federal office of child support enforcement. Hamilton County Juvenile Court performs under 45 CFR subsection 302 34 contractual obligations to the 42 U.S.C. subsection 654.3 4D program as 45 CFR subsection 75.2 contractors under 45 CFR subsection 303.107 requirements C, which specifies that the parties will comply with Title 4D of the Act implementing federal regulations and any other applicable federal regulations and requirements. Let's continue, guys. To gain employment by Maximus, Elrod furnished a Social Security number on government tax forms which, pursuant to, he spelled which wrong, but let's continue, pursuant to 26 CFR subsection 301.6109 1G is identified in the records and database of the Internal Revenue Services as a number belonging to a U.S. citizen or resident individual, a citizen under 8 U.S.C. subsection 1401, and a resident under 26 U.S.C. subsection 7701B1A have a common legal domicile in the United States, which is defined as the District of Columbia, and a 28 U.S.C. subsection 300215A corporation, furnishing the SSN on the federal and state tax forms succeed Elroy to the status of a federal employee or public officer on official federal government business. 20 CFR subsection 422.104 describe the conditions that an SSN may be issued. Then it states, the court takes notice that Title 20 pertains to employee benefits, which means federal employees and not private employees. This means the number can only be issued to and therefore used by federal employees on official business. 20 CFR subsection 422.103D furthermore states that the SSN are federal government property, which, okay guys, we on page number 2, and basically the whole second page was about nothing but him talking about Social Security numbers. This has nothing to do with stating the claim upon relief to be granted. But let's continue. Can only be issued to federal government employees on federal government business. Elroy also checked on her application that she is in fact a U.S. citizen. Pursuant to 19 Corpus Juris Secundum, CJS, corporations, subsection 886, a citizen is a resident or inhabitant of the state or country by or under the laws of which it was created, and of that state or country only. Oh man, like I said, none of this have anything to do with stating the claim, but let's continue. The federal OCSE is under the direct control of the Secretary of the U.S. DHHS, which is a foreign corporation with respect to this state. 19 CJS subsection 883 and is a corporation of the United States under the law which it was created. 19 Corpus Juris Secundum, corporation subsection 886, with a case law to support that nonsense. But let's continue. Williams is not a U.S. or state citizen, nor is he resident of Hamilton County within the meaning. He is a man with the national origin of an American national, created by God, and he dwells on real land, North America, in a non-domestic capacity in the country of Tennessee, a portion of the earth surface outside of the corporate U.S., Tennessee, and Hamilton County jurisdiction. Williams and Maximus and Elrod are diverse in citizenship because they differ in nationality. Therefore, diversity jurisdiction is proper under 28 U.S.C. subsection 1332. But that's far from the truth, guys. You know why? Because Williams is in fact a resident of the state. We know that. Why? Because he filed a change of address. So as a matter of fact, let's go over the change of address just to further prove that. Okay, so as you all can see, this document on the screen was filed April 19th, 2018, and where? In the District Court, Middle District of what? Tennessee. Remember, the original complaint was filed in the District Court of Tennessee. That's why I have the header right here on this document stating District Court of Tennessee. As you all can see, the plaintiff is James F. Williams for James Frederick Williams. It's all the same. Against who? Child Support Enforcement Agency at all. He filed this document in federal court, and this document is titled what? Change of address notice. So he filed a change of address notice, but his address is now is at a P.O. box in Nashville, Tennessee. Okay? The same people he said he knew not to reside at. But to make it even worse, guys, if we stroll down, what did that say? That's not a street address. Nashville, Tennessee. Yes, indeed. So, by him filing this change of address, he basically said he was a state citizen. But on his documents, he said that he's not a state citizen. Like I said, man, these cats don't know or have a clue of what they're doing, man. They actually just testified against his own self in federal court. Then he say he's not, so he just basically perjured his own self. Don't even understand the simple reality of what he have done. But let's go back to the original complaint. Let's go back there. 3. Merits of fraud claims. Maximus contends it is the market leader in 4D services with rewarding history of $389 million in collections for 646,000 children and their families. However, defendants openly admitted committing fraud pursuant to Blessings v. Freestones. The United States Supreme Court explained the requirements that a state operates its child support program in substantial compliance with Title 4D. Was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right, far from creating an individual entitlement to services. The standard is simply a yardstick for the Secretary to measure the system-wide performance of a state Title 4D program. Thus, the Secretary must look at the aggregated services provided by the state, not to whether the needs of any particular person has been satisfied. Furthermore, participation by the state 4D, okay, so now as you all can see, we're on page 3, and he still haven't stated a claim upon relief can be granted. Let's continue. Program is voluntary, V. Hutt versus Littbetter, in an Oliphant slip at 16, the state, like other states which have voluntarily agreed to participate in the AFDC program, are required to offer 4D services as a condition of receiving federal funds. Case law to support that. Still, guys, haven't stated a claim upon which relief can be granted. Maximus is a private business, and Elrod is a collection agent with a strong incentive to collect support because their profit generally is a percentage of the 389 million collections they make. Wherefore, participation in the child support program by the state and country is voluntary, and nothing in 4D shall be construed to mandate participation. So the fraud was a deliberate deception by Maximus and Elroy to secure unfair and unlawful gain and to deprive Williams of his protected rights. Okay, again, still haven't stated a claim, but let's move forward. 4. Venue. Venue in this court is proper as to Maximus and Elrod pursuant to 28 U.S.C. subsection 1391 A2 and B2 because constitutional deprivations giving rise to the claims were the results of contractual obligations, performance requirements, and regulations occurred within this district. Maximus Inc. is a private corporation and its corporate headquarters resides in Reston, Virginia. Elrod is an employee of a private corporation and not the Tennessee government. It is contracted by the state of Tennessee, Department of Human Services, local office, and falls short in the defense of qualified immunity, which protects government officials, not private businesses, from liability for civil damages. Their conduct did violate clearly established statutory and constitutional rights of which a reasonable person would have known. Again, guys, haven't stated a claim as of yet. Let's continue. 5. Claims are factual, not conclusionary. Defendant contends that Williams' claims are conclusionary allegations. which they are, but let's continue, consisting of or related to a conclusion or assertion for which no supporting evidence is offered. Factually, the defendant did, under contractual obligations, aid and abet the 42 U.S.C. subsection 654.3, the 45 CFR subsection 302.34 county court, and its 45 CFR subsection 75.2 contractor, which is factually provided on the court's website. Like I said, this had nothing to do with anything, guys. But let's read the conclusion. Conclusion. Title 42 Public Health and Welfare Code is comprised of the 4D of the Social Security Act, which is editorially compiled and organized into title, but Title 42 itself has never been enacted into positive law. The distinction is constitutionally sufficient because this non-positive law title is merely presumed evidence of law, and because 1 U.S.C. subsection 204 positive law titles constitute legal evidence of the law in all federal and state courts. Enforcement, collections, and court hearings were contractually conducted in compliance with Title 4D of the Social Security Act. But the public law, let's continue, 42 U.S.C. Subsection 651 as amended, and not the Tennessee or the Constitution of the United States. And this court should dismiss their hodgepodge and frivolous motion to dismiss because there is a factual nexus between Maximus and Elrod, who contractually deprived Williams of his rights, privileges, and immunities for profit that results in the injuries and damages he now suffers, which is now remediable by the defendants. Again, guys, he haven't stated not one claim upon which relief can be granted. But let's continue. Plaintiff states that defendant's present motion to dismiss fails and must be denied, being that they raised no new grounds for dismissal, especially when grounds raised in present motion was raised and denied in the Middle District of Tennessee, which is false, guys. The claim that was raised in the Middle District of Tennessee was held as moot. Why? Because that court did not have jurisdiction to make the ruling, so they sent it to Chattanooga County, where it's at now, and they will make the rulings on the motions that wasn't ruled upon in Tennessee. That's it. That's all. But again, when you have someone who lacks understanding and can barely comprehend any type of law, then they will quote some nonsense like this on a legal document. But let's continue. Plaintiff also states that the district court in Nashville ruled by law plaintiff's original complaint is the operative complaint. See attachment 1, court's reports and recommendations. Again, guys, that's it for this one. But that's all I'm gonna do for today. Like I stated before, if he think this right here is going to help him after that motion that the defendants filed, Maximus and Elrod, he don't have a thing coming, man. So again, like I told you before, when people come on people's YouTube channels to try to talk trash, brag, not knowing what I know, because I know for a fact this cat is about to get embarrassed when he received the order from the court when they rule on these motions to dismiss. It's going to be a sad day for that cat and for the other guy, Gary Lynn Scott Jr. Both of them cats came on this channel talking trash. When both of them lose, hey, man, I'm going to have a field day. And it's just that simple, man. But look, again, that's all I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's continue to apply this pressure to these phonies out here, man. These scam artists is out here scamming people, telling them to file suits in federal court, and they haven't won their own suit in federal court. Matter of fact, they haven't even proven that they ever won a child support case, period. So again, guys, you all be blessed out there. Like, share, subscribe. Part 4 be coming up soon. With that being said, guys, I say shalom.